Hey everybody, welcome back to Tim Travels. It's Terry, your host, coming to you from the Loves in Cumberland, Maryland. Of course, Cumberland is the Queen City, at least here in Maryland. It's also the Allegheny County seat. It's a big railroad town. Anyway, I wanted to throw, I'm actually going to put out a few videos in quick succession to address some stuff that people have been asking me about. And you know, if you guys know anything about me, my motto is give them what they want. It's also a good 10,000 Maniacs song, but yeah, the people want stuff, I deliver. So first matter on the docket today is actually the new arbitration agreement that was sent out by Prime, requesting signature and stuff. So nothing in particular really jumps out at me in this agreement. It's, you know, governed by the Missouri Arbitration Act, which I think is section 435 of the Missouri revised statutes. It's pretty easily searched, but the one thing that I did notice is that there's an opt-out provision from the arbitration agreement, and that provision can be triggered at any time prior to executing the arbitration agreement, or it can be opted for within 30 days of the date that somebody executes that agreement. Now, the thing I found interesting is that they sent the arbitration agreement to me, and if you're like me, they probably sent it to you, and it has my name and driver code in the footer of each page. But here's my problem with that part of it. I technically don't have contractual privity with Success Leasing. My truck is leased by a corporate entity. So I think it's a little bit odd that they want me to, it seems like me personally, to execute an arbitration agreement when, if there was a dispute over the lease, I'm thinking that I would probably, you know, if we took any action, that it'd be in the name of our entity, our LLC. But so that's like one little minor technicality, but it does matter. But the other thing I would say is that generally, I don't like arbitration agreements. I think because, you know, it's like saying, hey, you know, we want to, you know, we're going to play under a set of rules that probably favor the party that wants arbitration. And, you know, the party that wants arbitration is also the party that drafted the agreement, or their lawyers. So, you know, I think that, and by the way, under the Missouri statute, you can request that the arbitrator subpoena witnesses, and you can request production of documents. That doesn't mean that there are other tenets of discovery, and discovery just means getting information that could or could not be admissible in court as evidence from the counterparty in litigation. So, for example, you know, I tend to favor having the ability to go into court and use the rules of civil procedure to my best advantage. The other thing I would say about this arbitration is that, notwithstanding that the lease says that it's going to be, you know, adjudicated under the laws of Missouri, and there may be a forum selection clause. I mean, I didn't look, but I typically don't really give a crap what somebody says about that, because, you know, my company is a Maryland LLC. If I'm going to litigate with Success, guess where I'm litigating? In Maryland, where I'm licensed to practice. I can't really represent clients because I don't pay my bar dues, but that's a little thing. But if I needed to represent the entity that leases with Success, I'm sure I would just pay my bar dues and be able to represent the company that I work for. So I'm not a huge fan of arbitration. I think arbitration oftentimes is just it's a kangaroo court in a lot of places, and people are forced into arbitration where in a place they can't even attend the hearing or do anything, and then the arbitrator does some award, and next thing you know, somebody's getting a letter saying, oh, we got a judgment against you from this arbitrator and you owe us all this money. I mean, that happens a lot. And arbitration is like this tool that powerful parties, whether it's, a credit card company, a bank, a mutual fund company, there are any number of instances where they're like, oh, you can't litigate this in a court of law. You have to go to some arbitrator who isn't a judge, who may or may not be impartial. So I'm telling you, I'm not giving anybody legal advice. I'm just telling you my impressions of this arbitration agreement and what I will likely opt to do, which is to not be subject to the arbitration agreement. I don't have any problem with litigation. And people say, oh, well, arbitration saves you money. You can file a lawsuit in a lot of states for a very small amount of money, because courts, especially lower courts, want to make sure that everybody has access to the justice system. But oftentimes, just to start arbitration, right, just to preserve your rights, because a lot of times there's a time limit on a claim, right? So, and it differs by the type of claim. So if it's like a tort claim, like a personal injury, there might be one statute of limitations for that. Then a breach of contract might be a different statute of limitations. So, the thing is that in arbitration, a lot of those rules will apply, but sometimes there's a much bigger upfront cost to enter into the arbitration. Like each party has to pay half. Well, if the arbitration fee is, and these are set by the American Arbitration Association oftentimes, if the fee is $2,000, then that means that you have to cough up $1,000 just to arbitrate your claim. Whereas, for example, I could file what is called a small claim in Maryland District Court, I think for like $43, and you could actually hand write it. I mean, the court makes it, getting your day in court accessible. So that's the other downside to arbitration sometimes, is people are like, what the hell? I gotta cough up, $200 or $800 or $1,000, but it's only $25 to file a small claims case in court. That's the other part of arbitration that often hurts the small guy. It wouldn't surprise me to learn that arbitration in, like, say, securities cases, like you have an issue with your IRA custodian, your 401k custodian, there's an arbitration clause in there. Securities law is fairly complex, and you know, it wouldn't surprise me that some arbitration case they want like, you know, $2,000 to $5,000 for, you know, to get the case started and get the arbitrator involved. Because often the arbitrator is just another lawyer, but they're going to charge some fee, and if one party can't pay it, then the other party might just get some kind of arbitration award, or the case will get dismissed. So anyway, those are the things that I think about. Maybe they're the things that you should think about. But again, I'm not giving you legal advice. I'm not telling you to sign it or not sign it. I'm not telling you to opt in or out. I'm just telling you what the agreement says that I saw, what the law could be, and what some of the pitfalls of arbitration are. So anyway, hope this was helpful, and I'll be back with you soon. Bye.